Namaste and welcome to a presentation on company meetings. In this presentation, we will have a look at company meetings in three components. What is the meaning of meetings? What are types of meetings? And what are the requisites of meeting? This is part B video. This will cover point 3 and point 4. Balance points are covered under part A. Notice and quorum having seen, now we are talking of conducting a meeting. How it has to be conducted? It has to be conducted by a chairman. Let's look into the chairman part of it. And properly conducted means it is a valid meeting, should be conducted according to rules decided by voting. Every meeting must have a chairman and he should be elected in a proper way and he should act in an impartial way. Section 1041 says, members personally present at the meeting shall elect one of themselves to be the chairman by show of hands. One personally present, second elect one of them by a show of hands. Election is by show of hands. Now if someone raises objection, no, not by show of hands, we want a poll to be conducted, it shall be taken forthwith. And who will conduct the poll? The chairman who was elected by show of hands will conduct the poll, and after the poll the new chairman will take over for the rest of the meeting. Chairman, his election, if there is a contest, poll after poll, the chairman for the rest of the meeting will continue. And whenever a company is not able to hold its general meeting or extraordinary general meeting, the National Company Law Tribunal can pass an order to call a meeting. In such meetings, the order may also indicate who can be the chairman and what will be his second or casting vote in the absence of equality of votes. And these rights of the chairman on a casting vote is always subject to the articles of the company. Chairman selected by the members of the committee, and chairman may also be appointed by NCLT when a meeting is convened by NCLT under 97 or 98. And when the meeting is conducted, a member can attend in person or by proxy. Let us understand what is this proxy part of it. Proxy has two meanings. One, a person who attends is an agent. He is called a proxy. He attends and votes on behalf of someone else. And he carries a sheet of paper with him, authorizing him to attend the meeting. And that is a document. Proxy is both an agent and a document. And proxy is the agent of a principal. Therefore, it is a relationship of principal and agent. And whoever attends as a proxy need not be a member. He is representing a member. And once proxy is given, a person will attend the meeting. But can the member who gave the proxy, can he withdraw it? Can he cancel it? Can he revoke it? Yes. Before the meeting, he can deposit a fresh form of proxy which cancels the old one. He may decide to present himself in the meeting, then the proxy is cancelled automatically. If the person who gave the proxy, if he dies or he becomes insane, then it becomes a revocation, automatic. Therefore, a proxy once issued can be revoked by issuing a fresh set, or by presenting oneself directly, or by incapacity of the person who issues the proxy. Provisions regarding proxy are contained in section 105. It says a member is entitled to appoint a proxy in terms of the Act. But a proxy who attends the meeting shall not have right to speak. He can only participate in a poll. And central government may prescribe a class of companies where it can say you cannot appoint a proxy. It is up to the central government for some special reasons. And when a person attends as a proxy, he has got a limitation of representing a maximum of 50 persons or such number of shares as may be prescribed. Means proxy has got a ceiling. Every notice which is given to members, it prominently states a member is entitled to appoint a proxy. You can appoint one or more proxies, and the proxy need not be a member. One or proxies means if you have say 1000 shares, you can split it into two. One person with 800 shares may be a proxy. For the balance 200, there can be one more proxy. The instrument of appointing proxy, the proxy has to be deposited with the company 48 hours before the meeting. And company should not suggest any list of people to be appointed as proxies. Any invitation to appoint proxies is an objectionable practice and it is punishable. Appointing proxy is the discretion of the member. It should not be at the instance of the company. And the proxy instrument, it has to be in writing. It has to be signed by the appointer. And it should be in the form prescribed. And whatever proxies which are deposited with the company before the meeting, they can be inspected. But to inspect them, one has to give not less than 3 days notice before the meeting. And once you give 3 days notice to the company, during the period beginning 24 hours before the commencement of meeting and ending with the meeting, the period commences 24 hours before the meeting. It continues throughout the meeting till the end of it. One can inspect the proxies during business hours which are deposited, and as we noted, he should give not less than 3 days notice in writing before the meeting. And it has to be given by member entitled to vote. A non-member cannot inspect the proxies. We have seen the proxies. And in a meeting, voting takes place. And the voting takes place in different manner. Let us first take up the voting pattern of show of hands and poll. Section 106 says voting right is the right of a member, but articles may provide that the right may be prohibited to be exercised if there are calls in arrears. If a shareholder has not paid his calls on the shares, the articles may prohibit him from exercising his vote. But it is a right of the member. Yes, but right of the member can be stopped. The voting right can be taken away by the company only when only when the calls have not been paid and there is a lien exercised by the company. Other than this ground, there cannot be any restriction on the voting rights of members. And when a person attends a meeting and in a poll, he has to put on his votes. For example, if you have got 100 votes as a proxy, you can put 100 in favor of the resolution, you can put 100 against the resolution, or you can split also. You can use 60 for and 40 against. What it says is, on a poll taken at a meeting of the company, a member entitled to more than one vote or his proxy need not use all his votes in the same way. It is his right. He can use the way he wants. He can split it. It is so far as the poll is concerned. In case of a show of hands, unless a poll is demanded, voting or voting is carried out electronically, either there is a poll or there is an electronic voting. If both these are not there, it is always decided by the show of hands. Therefore, as we saw in case of chairman, first show of hands takes place. If there is a requirement or demand for poll, the poll may be the regular poll or it can be an electronically operated polling mechanism. And once the polling is done, or in a show of hands, once the chairman declares the resolution is passed by show of hands, it is a conclusive evidence. Conclusive evidence means it cannot be reopened. It is finally closed. Conclusive in the sense it is not subject to further evidence. It is proof of the event having taken place and closed the way it has been declared by the chairman. It is not subject to further evidence or further inquiry. Then there is demand for poll. Once the show of hands takes place, or even before it takes place, the chairman on his own can decide to go for a poll, or shareholders who are having 1/10 of the total voting power or having paid up capital of rupees 5 lakhs can demand a poll. Then the chairman has to conduct the poll. And you can make a poll and you can withdraw it also at any time before the poll takes place. And if a poll is demanded for adjournment or for appointment of chairman, it cannot be postponed. It has to be held immediately. Two purposes: adjournment of the meeting and appointment of chairman has to be taken immediately. But any other than this can be taken up later, but within 48 hours of demand for poll. And how does the chairman proceed? He will proceed sufficient number of people as scrutinizers, and he will collect the votes cast through the scrutinizers, and the result of the poll will be declared, and that will be the decision of the meeting. Show of hands leads to poll. Poll has to be held within 48 hours and results declared as the decision of the meeting. We have covered the show of hands and poll, and now the improvement which has come back is electronic means, voting by electronic means, and this is the advantage to the members. It says under section 108, the central government may prescribe companies or classes of companies where the voting shall take place through electronic means. And this is indicated in Rule 20 for the procedure. Now, this rule applies to general meetings. Every listed company shall have electronic voting where the number of members is not less than 1000. Invariably, listed companies will have that strength. Therefore, indirectly it means it is compulsory to have electronic means voting in respect of a listed company. And in this case, the notice will be sent to members by registered post or speed post or by email or courier. The notice also will be placed on the website, and the notice will state that the company is providing facility for electronic voting. And facility for voting will have two aspects. You can vote through electronic voting remote, or you can vote in the meeting with polling paper made available at the meeting. It is a combination of both. You can vote remote on electronic, or you can be present in the meeting and then vote. And there also you can either use polling paper or you can use the electronic media. The notice also will indicate the process and manner of voting. It will indicate the time schedule. It will also indicate the login ID and the password for a member to log in and cast his vote on the net. And it also further says whenever you are having a listed company which is going for electronic means, you need to give a public notice 21 days before the general meeting in a vernacular newspaper and also in English newspaper, wide circulation. What it will highlight, it will say company is allowing voting by electronic means. When will the electronic voting commence? And what is the date of ending of the e-voting? What is the cutoff date? And how to obtain the login ID and password. This is published to ensure that electronic voting becomes a habit. And it will also give the website address of the company for any grievances to be addressed. There will be an email ID and telephone number, and the public notice as published will also appear on the website of the company. And electronic voting will be open for 3 days and it will close at 5 p.m. a day before the meeting, day preceding the meeting. Means you can vote for 3 days till the day before the meeting up to 5 p.m. And once the vote is cast electronically, he cannot change the vote because the next day the regular meeting will happen. And once you have voted electronically, you can still participate in the meeting. But if you have already voted on electronic media, you shall not be allowed to vote again in the meeting. And even in the meeting, people who have not e-voted before, they can use either the polling paper method or once again they can use the e-voting. And what the board will do is they will appoint one or more scrutinizers, and the scrutinizer has to give his consent to be appointed as such. And the poll will be taken and they will be in control of both remote electronic voting and voting inside the meeting premises. And the scrutinizer, after he counts the votes cast in the meeting, he will unblock the votes cast on e-voting till the day before, and he will make a report on the results of the voting within 3 days of conclusion of the meeting. He will present the report to the chairman. The chairman will declare the result based on the report received by him. And the scrutinizer will maintain the register to record all the assents and dissents, or the votes actually received on the system, as a part of record of the company. And the result as given by the scrutinizer to the chairman will be filed along with the minutes which are signed by the chairman, and the results declared will be placed on the website, and it will all be sent simultaneously to concerned stock exchanges. And all resolutions passed by e-voting are deemed validly passed in a meeting. And needless to say, a resolution which has gone through the electronic means cannot be withdrawn. Effectively, electronic means is a switchover of technology for casting the vote. Instead of using show of hands or on a poll, you can go for electronic voting, either remote or within the meeting, and this is a additional empowerment of shareholders. And there is one more item called postal ballot. This is once again more strengthening the shareholders' rights in management of a company, and it is an improvement over once again electronic means on specific types of businesses. What is a postal ballot? Here, meeting or no meeting, it is a subject which is important. Section 110 subsection 1 says central government can declare voting only by postal ballot in respect of matters other than ordinary business. Ordinary business, as we saw, pertains to financial accounts, directors, audit, and dividend. Other than these four, there can be a measure of postal ballot. Instead of holding a meeting and discussing it at a general meeting, they can just go about in the postal ballot, and that will solve a lot of procedures. At the same time, it will ensure every shareholder has got a say in the decision of the meeting. And the procedure of postal ballot also is in combination with electronic means. Means even when you are sent a postal ballot at your personal address, you can send your vote either by signing the form, or you can go for e-voting on the terminals provided by the company. Let us get into the details of it. Rule 22 says the procedure. Notice sent to all shareholders along with the draft resolution, and it will ask them send your assent or dissent in writing by postal ballot sent to you, voting by post or through electronic means. You have to send, the member has to send the consent or dissent within 30 days. No physical meeting. Notice is sent to him and 30 days time is given, and it is sent by registered post, electronic or courier service, and a detailed advertisement is given in English and vernacular detailing how the meeting, how the voting is proposed. It says the advertisement will contain these details. When is the completion of dispatch of notice? When will the voting commence? When will the voting end? And it will also say you have got 30 days to respond any vote beyond those 30 days will not be valid. People who have not received any notice papers based on the newspaper can obtain a duplicate, and they can also lodge their grievances with the company. And the notice of postal ballot is also placed on website. This is just to take the vote directly from the shareholders without calling them for a meeting. And one scrutinizer will be appointed by the company with his consent, and he will be in charge of the receipt and safe custody of all the votes received by post. And there is a last date for receipt of the postal ballots, and he will prepare his report within 7 days of the last date for receipt. And he will prepare a report and take custody of all the papers of voting received by him. He will also include votes cast by electronic means, and the results will be declared based on the details provided in the report, and it will be declared on the website. And whatever rules applicable to voting by electronic means will equally apply to voting by postal ballot. Now we have to understand where this postal ballot is insisted upon. It is insisted upon by the government where interest of the shareholder is more important, for alteration of objects, for removal of conditions which are there in the articles of a private limited company, change in the registered office outside the present local limits, change the objects when the company has already raised money and the money remains unutilized partially or fully, and issue of differential rights, variation in the rights of shareholders, buyback of shares, appointment of directors by small shareholders, sale of part or full of the undertaking, giving loans or guarantees in excess of the limits. For all these businesses, the government has made it very compulsory that it has to be through electronic means and postal ballot, and a combination of the two. Therefore, all major alterations to memorandum will not wait for a meeting. It will be done through a postal ballot, which is a foolproof method to involve every member. We have seen proxy voting, then comes the resolution. All decisions which are taken in a meeting are called resolutions. We can just say, when you introduce a draft resolution, it is called a motion. When it is passed by requisite majority, it becomes a resolution. Means resolution is a formal decision of a meeting on a proposal. Motion gets converted into a resolution. There are two sets of resolution: ordinary resolution and special resolution. What is ordinary resolution? Ordinary resolution is considering votes cast for or in favor and votes cast against. If for or favor is more than against, that is, if favor exceeds against, the resolution is carried. If against exceeds favor, the resolution is dropped. Now, what votes are included here? All votes. Votes by, whether by show of hands or by electronic or by poll, and also by casting vote in case of equality votes. Therefore, simple, in ordinary resolution, you take favor against, and favor has to be more than against to carry an ordinary resolution. Then what are the ordinary resolution instances? Ordinary resolutions are once again for the normal business: dividend, appointment of auditors, electing directors, and passing of annual accounts. These are ordinary resolutions which should be having votes cast in favor more than against. But there are other resolutions which are special resolutions. What is the meaning of special resolution? In a special resolution, the votes cast in favor as compared to vote cast against should be not less than 3 times. It is always called the rule of 75-25. If votes cast against is 25, then for a special resolution to be passed, votes cast in favor has to be 3 times or more. It should be 75 and above. This is in respect of special resolution. Special resolution is one which is passed in matters other than these 4. And the logic is very simple. And the notice has to indicate it as a special resolution with annexures. And what happens when a resolution is passed? It is introduced on one day, it is passed on another day because of the adjournment of the meeting. The question comes, when was the resolution passed? Was it passed when it was adjourned, or was it passed when it was put to vote and the votes were cast? The act is very, very clear. A resolution passed at an adjourned meeting is considered as passed on the date on which it was passed. When it was voted upon is the date of passing of the resolution and not on the date of introduction of the resolution. This is so far as conducting of the meeting. Once the meeting is conducted, it has to be documented. Now, documentation, we have got 3 aspects of documentation: documentation in electronic form, minutes of the meeting, and filing of resolutions, agreements, and reports. Let's have a look at that. Let us start with the electronic form. Maintenance and inspection of documents in electronic form, section 120. It says, all documents, records, and registers required to be kept by a company are allowed to be inspected or copies taken, and for that purpose they are kept, inspected, or copies given in an electronic form. There need not have to be physical handing over of the copies. Rule 27 says to give this you have to maintain inspection documents in electronic form. A listed company, as we saw, not less than 1000 shareholders, may maintain its records. Though it is not mandatory, it is desirable to maintain in the electronic form, and the existing companies can convert their hard copies into electronic mode. Board takes a decision as to in what form it has to be kept. The records shall be maintained in the same formats. They may be in the electronic records, but the format has to be as per the Act. They should give adequate information. The record should be readable, retrievable, and reproducible. And the records should be capable of being dated and signed digitally. They should not be capable of being edited or altered. They are a record, but they should be capable of being updated with the date of updating and recorded on every updating. And the record includes a register, index, agreement, memorandum, minutes, or any other document. It means maintaining all records in electronic form. This is so far as inspection of the documents is concerned. Then comes the minutes of the meeting. You can have the minutes of the meeting. Section 118 subsection 1 talks of every meeting of shareholders or creditors or postal ballot, or every meeting of board. These are three classes of meeting: shareholder meeting, resolution passed by postal ballot where there is not a meeting but document of voting is there, and there is meeting of board, or there may be a committee of board also. They all shall prepare minutes within 30 days of the conclusion of the passing of the resolution, and the minutes will be kept in the form of books which shall be consecutively numbered on pages. What the minutes will record? They will record a fair and correct summary of the proceedings of the meeting. They will record all appointments, and specifically in case of a meeting of the board, it shall also contain names of directors present. In respect of each resolution, directors dissenting from the resolution will be mentioned specifically. But chairman has got a right to refuse inclusion if he feels the matter is defamatory or it is irrelevant or detrimental to the interests of the company. Chairman has to use his absolute discretion, and minutes are produced as an evidence of the proceedings as and when it is required, including in courts. And they are an evidence until contrary is proved. They are not conclusive evidence. They are evidence of proceedings, but they can be contested and they are deemed to be valid. And the proceedings of the annual general meeting normally will not be advertised at the expense of the company. If it is, it should be strictly based on the contents of the minutes, and the minutes should follow secretarial standards, and any non-compliance or tampering with the minutes renders liability to fine and penalty for the offense. Minutes of the meeting, they are kept at the registered office and shall be open to inspection by any member for not less than 2 hours in each business day, and the company can give him a copy against a fee within 7 working days. If the company refuses to give it, it will be liable, and every officer in default also will be liable in penalty. And wherever there is a refusal or default, and if the tribunal is approached, it can direct an immediate inspection of the minute books and order for a copy to be given to the concerned person. Then comes the filing of resolutions, agreements and reports. Section 117(1) says every resolution, explanatory statement shall be filed with the registrar within 30 days of the passing, and every resolution effecting alteration of articles shall be embodied or annexed to the copy of articles. Any company that fails in this regard will be liable to penalty, and every officer in default attracts punishment. Provisions in respect of filing. Special resolutions, resolutions passed as unanimous resolutions but which have been passed as a special resolution. Any resolution appointing director or managing director. Any class resolutions which are passed as unanimous but would have been required to be passed by a specified majority. resolutions requiring companies to be wound up, resolutions of buyback, borrowing and investing beyond certain limits, any other resolutions as may be prescribed. These are the resolutions to be filed under 117(1) with the Registrar of Companies. And the company also has to prepare a report on annual general meeting. Every listed public company shall prepare a report once the meeting is over that the meeting was convened, held and conducted as per provisions of the Act. And a copy of the report will be filed within 30 days of the annual general meeting. And any failure will attract penalty for both company as well as the officer in default. This report is in addition to the normal report which will be prepared by the company. It will be signed by the chairman. It will indicate the day, date and venue of the annual general meeting. It confirms that appointment of chairman was held in the meeting. Members attending the meeting, the number. It confirms the quorum. And it confirms compliance of the Act and rules in calling, convening and conducting requirements of meeting. It details the business transacted and the results thereof. And it will contain a fair and correct summary of the proceedings of the meeting. And a copy of the report shall be filed with the registrar within 30 days of the conclusion of the meeting. This is report on the annual general meeting. Thus, we have seen in requisites of meeting, convened, constituted, conducted and documented, starting with notice, annexure to notice, circulation of members' resolution, resolutions requiring special notice. We have focused on the quorum, chairman, proxy, voting, electronic means, postal ballot, ordinary and special resolutions, documents to be inspected in electronic form, hence to be kept, minutes of meetings, and filing of resolutions and reports with the Registrar of Companies. With this, we have covered the portion of conducted and documented part of requisites of meeting in video B. Please watch video A for the balance topics. Thank you so much. Thanks a lot.